Welcome to our program, Thomson Reuters versus Ross Intelligence, AI and Fair Use Implications Going Forward. I'm Randy Bandman, Chair of the Entertainment Law Section of the Beverly Hills Bar Association, and I'm delighted to introduce today's speaker, Jeremy Goldman. Jeremy is a partner in the law firm of Frankfurt, Kurnit, Klein, and Selz PC's Litigation Group and co-chair of the Emerging Technology Group, focusing on intellectual property, entertainment, media, privacy, technology, and commercial law. Jeremy is an accomplished media and entertainment litigator, focusing on copyright, trademark, privacy, intermediary liability, right of publicity, First Amendment, and business disputes. Jeremy draws on his sophisticated understanding of law, technology, and industry, along with creative problem solving and litigation skills to help clients navigate complex legal challenges in and outside the courtroom. Beyond his litigation practice, Jeremy advises startups and established companies on intellectual property, commercial licensing, and privacy matters, especially when transactions and projects intersect with emerging technologies like artificial intelligence, blockchain, and new media. Before we begin our program today, I wanted to point out that you, our audience, could submit questions in the Q&A box in the Zoom channel, and Jeremy will do his best to address as many as he can before he concludes. Thank you, Jeremy.
You are welcome. Thanks, Randy. Hi, everyone. Thanks for joining today. So excited to present today on Thomson Reuters versus Ross Intelligence. We're going to be covering some context and background involving AI and fair use and the big AI copyright-related litigations that are going on. I know there's been other programs that focus more on the landscape generally and the litigations generally. We are going to get into more of a deep dive of the fair use issues, and in particular, the first meaty decision, I should say, that's come out in the AI copyright litigation landscape involving fair use. And so that's what we're going to do today. So happy to jump in here. I'm going to share some slides. All right. Randy, we're good. You can see them?
Yes. Okay. Thank you.
Thank you. Okay. So how are we going to get there? How are we going to get to Thomson Reuters versus Ross? Because to jump right in would lose the forest for the trees here. So introduction is done. I've completed it. We're going to talk about generative AI generally, and I'm going to go through some key concepts talking about what generative AI is. And I'm going to assume that most folks here have some knowledge already of, ChatGPT and the like, but I'm going to try to give a little more nuance and definitions for folks to come out with a bit more education and knowledge around these concepts. We'll talk about some of the models, the training. Then I'm going to do like I said, an overview of the litigation landscape as it stands right now. It's rapidly changing. We'll talk about there's dozens of cases. So of course we won't be able to cover them all or even any of them in any detail, but I want to give the landscape because it's important to the case and issue at hand. We'll do a sort of a case study of probably the highest profile AI copyright case that's going on right now, which is New York Times versus OpenAI. And we're not going to talk about any fair use rulings in that case because there have been none. But I think understanding the facts and the background of that case and the nature of the fair use question that is likely ultimately resolved unless the case resolves earlier. I want to set that up. And then we'll pause and we'll take a step back on the legal front, talk about fair use generally. I'm really not going to, make this, again, a 101 course where we're going to plod through the 4 factors of fair use, although we'll cover it. Instead, what I'm going to do in that section is go through some of the key cases that I believe are going to figure into the court's plural analysis as they try to wade through what I see as sort of the biggest copyright and existential question facing sort of technology today, and that is whether the use of copyright protected materials to train AI is fair use. With that foundational knowledge of fair use, we will then jump into the recent decision, recent meaning exactly 1 month ago, really, February 11th, 2025, coming out of the District of Delaware with the Thomson Reuters versus Ross Intelligence case, which is why you're all here today. So we'll go through that case in some level of detail and learn how the court tackled fair use in that case. And then I have some slides that really are more for sort of in-house counsel, talking about the business risks and practical considerations that come out of these various AI cases, and with a focus on the recent Thomson Reuters decision. We'll see if we have time to get to that. And it's interesting. I think I see that there's no real questions coming in yet, just links to program materials. Terrific. Okay. Folks can try to put things in Q&A. If you have questions, I'll either get to them at the end, or if I'm savvy enough, I'll try to grab them as we go along. So thank you. Starting with generative artificial intelligence, and really artificial intelligence in general, let's just talk about some key concepts here. Generative AI is artificial intelligence, and I'm not going to even attempt to define what that is. It's all over the place. But what makes generative AI interesting is that it allows you to produce new content, text, images, videos, etc. And the way that it does that is by identifying patterns in very large-scale data sets. And in terms of sort of historical context, what's important to understand is that artificial intelligence, of course, has been around for a very long time. But in the past sort of 3 years, there's been significant breakthroughs along the lines of the Industrial Revolution. If you're going to, find a metaphor, an analogy, with certain technologies involving transformer architecture and giant neural networks. And so with the speed and capacity of computers and some of the ways that they figured out how to dump massive amounts of data and use processors that can do parallel processing at the same time. So you're not just getting a computer and it's spitting out an instruction at once. Rather, a computer can, in parallel, deal with multiple instructions and ingest material at a very rapid pace. What the developers figured out was that by dumping in vast amounts of data, they can create these large language models, which are artificial intelligent models that are trained on these huge text corpuses, or corpora, I think is the word, that instead of just predicting behavior, what they're able to do is take in this large amount of text or other data, and it's able to convert that into a alphanumeric string, and then find relationships between patterns and relationships between one word and the next. It's called like a weighting process, and it could predict the next word that's going to appear based on the prior one. And it doesn't do that using words. It does that in the language of computers, where it converts, like I said, these text strings that are natural language, and it converts them into these alphanumeric strings that are very complex and can find relationships between one word and the next, and find patterns in the way that people speak in language. Now, that sort of concept has been expanded, and it's no longer just about text, but they can also do it, of course, with images, video, sound, and the like. And there's been an explosion of tools, and we'll look at some of those. Again, just going through some of the terminology. Prompts are the inputs that users or the system sometimes you put into one of these AI models to guide the model's response. And outputs, of course, are the text, images, or other content that is created and shown to the user or generated from the AI. How are these models trained? Well, as I mentioned, they're trained using massive data sets with billions or sometimes trillions of data points that are ingested into these powerful machines to learn the patterns. Where do they get these massive data sets? And again, I think a lot of this is known. It's been in the news, and it's part of these cases. It comes from various sources, but it's come from websites. And the way that they do that is by either hiring a third party or themselves basically spidering, indexing the entirety of the World Wide Web. They've ingested books, vast amounts of social media posts, massive code repositories of open source code that live on places like GitHub around the web. And in addition to text, there's also AI, as I mentioned, that's trained on images and video and audio sources. And what's what's implicit in this is that the text and the materials that are used to train this AI, it requires to do these large language models, like I said, a massive amount of data. And that data includes, for most models, includes materials that have been licensed, and we'll talk a little bit about that, and material that is unlicensed and may be copyright protected and unlicensed. Just to get a sense of the industry and the big players in the space. So you can all sound like you're knowledgeable about the artificial intelligence markets and industries. I think it's useful to break it apart between the foundational models, the applications that are released by those foundational models and the companies behind them, and then the plethora of, I call them vertical AI solutions that for the most part are leveraging and powered by the foundational models. And so in terms of the foundational models, there's really only a handful of them that are in play and sort of, at that level of being the giant platforms. They include OpenAI, which has its model GPT. Google has Palm or Palm 2. Anthropic with Claude. Meta has its model called Llama. These are all mainly acronyms. Stability AI, which works more with images. And then there was a lot of news in the last couple months around DeepSeek, which is a Chinese AI model and company, which sort of knocked the socks off a lot of the AI industry by coming out with a model called R1 that purported to be just as powerful as OpenAI, or OpenAI and GPT and the other ones that I listed, but allegedly without spending the amount of money and power that the others did. There's some skepticism around that, and we don't need to get into the details of that right now. So those are sort of the big players, and those players, in addition to the models which are underlying it, and you can't use a model. You need software, just much like you have an operating system, and you need applications to sit on top of an operating system. Here you have models. Oh, Grok 3, thank you. Yes, Gemini, Grok 3. I didn't list them all. Okay, so there are others. Thank you, Ralph. But there are other models, and the mainstream, the foundational models, they release their own applications. Of course, one of the more popular ones, ChatGPT, which sits on top of the GPT model. Bard is Google's version, which sits on top of its Google one, and so on and so forth. And then in addition to those applications sitting on top of the foundational models, you have, I think there's hundreds, thousands of applications that are coming out more every day that are vertical because they're often tailored to a specific industry, legal being a very big one. And there's, I put Harvey.ai, it's just one that I'm familiar with. Bloomberg GPT has one for financial data. Google is coming out with a medical LLM. And I have friends that are doing startups around this, and a significant, just a huge explosion of tools. And we'll look at one of them today. The case that we're talking about today is one of those vertical AI solutions that doesn't, is not a foundational model, but is leveraging other AI. And actually, is one of the, it's been around for a while, but we will get to that. So with this massive explosion in foundational models, in applications, and in verticals that are trained on, often trained on unlicensed data sets, it is not surprising that there has been a huge surge of litigation. And so let's talk about sort of first, we'll do a bit of a timeline of the key, what I see as sort of the key moments in the AI copyright related litigations. And then we'll look at it and we'll zoom out a little bit. So sort of very interestingly, and I guess it sort of makes sense, the first, really the first big one to get filed is the first one that had some sort of real fair use ruling, which is Thomson Reuters versus Ross Intelligence. That was filed out of all places in the District of Delaware that way back in 2020, I mean, that's going back 5 years ago. And before before ChatGPT had become a household sort of product and name. And that case, wound its way through the courts, and we'll get to that. So there's some poetry there. The next sort of big one that really launched, in my opinion, sort of the modern era of the AI copyright cases was a class action lawsuit. All the other ones all of these cases are still pending, I should say. Doe versus GitHub, which was in, oh, you want a PowerPoint? Okay, we'll talk about that later. Which was alleging an allegation by a class action lawsuit really filed by developers, coders, and in particular coders who released their software under open source licenses and posted them on the web for the taking, but subject to these licenses. They filed a lawsuit as a class against Microsoft and OpenAI, alleging that they violated their copyright, they violated the terms of the open source licenses, and they violated the terms of the DMCA, in particular, the provisions that relate to copyright management information, which we'll touch on, but it's not the focus today. And the reason they said they did that is because they ingested all of this code to create these applications, Codex and Copilot, which are applications that do predictive coding and, again, rely on these large language models that were created by OpenAI at Microsoft. And so that case was in 2022. That case didn't get a ton of attention. It was really when ChatGPT became big, and then and some of these other applications, and people started seeing the generative AI create these incredible images. When you saw Getty come on the scene, and then there's a class action that is related to it, also against the same company called Stability AI, which is one of the foundational models with tools connected to it. And they actually filed this lawsuit in the United Kingdom. There's a class action that's pending here, I believe, in California. And in that case, the allegation is that Stability AI ingested, maybe the entirety of Getty images to create its image generator, alleging that they're creating this competitive product by ingesting, tens of thousands of their copyright protected images. There's trademark claims, there's copyright management information claims, and the boot, but at the core of it is a copyright type of claim. And the next sort of big hit here is one that I mentioned that I'm sure most folks have heard of, which is when the New York Times pulled the trigger and filed a lawsuit against OpenAI, alleging that OpenAI and Microsoft, which is one of OpenAI's biggest investors, and alleged that OpenAI and Microsoft had trained their models using copyright protected articles and materials from the New York Times. And we will do a bit of a deeper dive into that case, really as a case study, but also, again, because it's sort of the hottest, most high profile case. Just to get into the nature of these cases, and I'm just trying to get, if it wasn't clear, just trying to give everyone a sense to get their arms around these litigations through different angles. And so now what I'm trying to look at is really distilling the nature of these cases more generally, who's suing who for what. And here, who's suing who, the answer is, the media really it's media companies, book authors, artists, music publishers, software developers, copyright holders, creators, and the companies behind them. And they are suing major AI providers and technology platforms. What's interesting here, I'll just do a quick note, who's not being sued so far, really users of these platforms, and I should say end users of these platforms. I'm not aware of any real litigation that's been filed against folks that are using generative AI tools or any of these tools, alleging that their sort of end use of the tools is violating copyright. I'm saying end user because in theory, a company like Ross Intelligence might be leveraging and using OpenAI or other tools. I actually don't know if it's OpenAI, so don't hold me to that. But I believe that they're powered by other third-party tools, but no end users have been sued yet. It's really the major AI providers, the big application providers. And the allegations are typically in the same penumbra of claims, which is that the AI developers one, that they scraped the internet. So there's a whole slew of claims involving web scraping that we're not going to get into today. It's a whole other area of law, but connected. But the one claim is you took all of this stuff and scraped it without permission and might have violated our rights just with the scraping. And then you, after scraping it, you then use that to train the AI and these tools for commercial purposes. And what kind of causes of action are they alleging? The sort of the main bucket of causes of action are direct and indirect copyright infringement. The direct claim being by copying our materials for the training and putting it in, it's a copy. But also there are allegations of indirect copyright infringement, both with respect to the web scrapers that are doing your alleged dirty work, and you have users, the allegation is, the end users that are using our products and tools to create images and outputs that violate copyright, and you are giving them the tools to do it. And so that's the indirect copyright claim. There are also, as I mentioned, claims under the Digital Millennium Copyright Act, which are not claims for copyright infringement, but are claims that the AI tools in the course of your scraping, in the course of your structuring the data to be interpreted and ingested by these AI tools, you have removed our copyright management information. You have removed the name of our publication, the name of the author, the terms and conditions that get attached to it, the metadata, information about the copyright, the allegation is, were removed by these AI tools. And the allegation is you did it intentionally, and you did it for the purpose of concealing the infringement down the line, so that when folks down the line are going to infringe on our rights, there's no way for them to know that there's sort of infringement because there's no copyright management information that is attached to it anymore. And courts have weighed in on some of those CMI claims, and it's just district court level decisions. They've actually been split on it, with 2 decisions recently upholding the claim, although going to require sort of a high level of proof in order to make out those CMI or DMCA claims, and then one court in the Southern District not allowing that claim to go forward. So there's a bit of a split, a difference of opinion on that issue, and indeed on the fair use issue, as we'll see. And then, sort of the other claims include breach of contract claims, which really arise out of the web scraping more than anything, where you have terms of service that are attached to the content that's online, and the allegation is that you violated those license agreements or those terms in doing so. So I have a question here as I'm trying to follow along. Are ingesting, copying, scraping effectively synonyms in AI cases? Great question. No, I would say they're not synonyms. I know I'm using them a little bit similarly. I mean, scraping, it's sort of the best way to think about that is, copying can occur at any level, where you can have copying during many different steps of the process that ultimately lead to a large language model converting text into weights and points, which are not text really, or not text as we know it. That can happen at any level. Ingesting is what I'm describing is the process of taking that text into the models, and then scraping is really it sounds so devious, but that is a particular type of copying where you go on the web and you have typically automated tools that copy the entirety of a web page, and so scraping is really specific to copying material that's posted on the internet. So they're all sort of different, similar types of things. So we're going to talk about constraining AI learning to a specific set of data, actually. So I'm going to get to that. All right. So now just another way of looking at the landscape here. Credit to Wired for this slide. And they're doing a really nice job of tracking these cases. This is just the visual, seeing the amount of cases that have been filed over the course of the last, basically 5 years, but mainly in the last 2 or 3 years. And so you can get a sense of who the plaintiffs are, who the defendants are in these cases, and they're pending all over the country. All right, as I hit almost the 30-minute mark, I'm gonna try to stop myself from answering questions. Not because they're not good questions, but because I want to make sure I cover the slides for everyone. And I'm happy to stay on for a while after if there's time, if folks are interested. Okay, New York Times versus OpenAI. This was filed in December of 2023. The docket is like 6,000 entries long, so I can't possibly dig into it in any level of detail. So I'm just going to give some sort of high points and give folks an idea of what the case is about and where it stands right now. New York Times, they're actually quite good writers over there at the New York Times. They wrote a very nice complaint that's not weighing in on the merits, I should say. I'm hoping not to give anyone any sense of my opinion on the merits of any of these cases. I'm here strictly as hopefully an educator. But the Times has for 170 years, more than 170 years, the Times has given the world deeply reported expert independent journalism. And the allegation is that the unlawful use of the Times's work to create AI products that compete with the New York Times, and that competition is going to be key, as we'll see. They're claiming that it threatens their ability to provide the service. And the allegation is that, as I just talked about, that they relied on these large language models that were built by copying and using millions of the Times's copyrighted news articles, their investigations, etc., that this was an infringement. And the allegation is, we'll just look at this because it's quite intriguing, that the allegation is that OpenAI and Microsoft's AI tools, they focused on ChatGPT and Microsoft, and the allegation was that these tools have the ability, so it wasn't just the ingestion, but they're saying that they have the ability to produce outputs that produce content verbatim or nearly verbatim, summarize it, and mimic not just the facts and the ideas that are included within the New York Times' articles and the way that we speak, but also they allege the expressive style, and they had attached an appendix and examples in the complaint itself where they produced large swaths of text that they claim were directly from the New York Times. And here you can see sort of a red line comparison that they put in the complaint. And you look at that, and man, it does look a little alarming. The OpenAI shot back, however, and says the allegations in the Times' complaint do not meet its famously rigorous journalistic standards. The truth, which will come out in the course of this case, is that the Times paid someone to hack OpenAI's products. It took them tens of thousands of attempts to generate the highly anomalous results that make up Exhibit J to the complaint. Again, to be super clear, I am not opining on whether they are right or wrong and what happened, but the allegation here or the response to the New York Times allegation of verbatim copying is essentially that New York Times beat the ChatGPT with a stick until it came out and said the things that they wanted to say. And OpenAI is sort of saying, they're kind of relying on the old, and we're not really going to get into those cases, so I guess I can mention it now, the old, when you create a tool that has substantial non-infringing uses and you are using it for an infringing use, then you can't blame us. And so, again, I'm not focusing on this component of it, but it is interesting to me that the New York Times is at least pinning some of its copyright claims on this allegation of verbatim outputs that are created by the software. Causes of action line up with the other slide, but since we're doing the case example, we could see how it fits to these facts. Claims for direct and various liability for copyright infringement, for both storing, processing, reproducing the training sets that include the works, and then disseminating outputs that are copyright, that are derivatives, they're claiming, or copies or derivatives. They're also claiming contributory copyright infringement, as I mentioned before, based upon the indirect infringement by end users of the product. And they're also going after Microsoft for saying that they are providing the infrastructure to host and operate and commercialize these various GPT models. They are claiming DMCA Section 1202 violations. Those are the CMI claims that we talked about. Again, for taking an article like the one we just showed, taking this on the left side, a GPT-4 model, and what is missing here is any byline, is any attribution to the New York Times, and they're saying that you have stripped that out, and now people might take that text and use it and that's going to perpetuate further infringement. They threw in an unfair competition claim by misappropriation and a claim for trademark dilution. I don't know what either of those are, being a copyright lawyer. Just kidding, I do know what those are, but we're not going to talk about them today. So just again, just in terms of the big milestones and giving us a little bit of a status update where we are in this sort of mega case. And again, this is not the only one. There are very important lawsuits, all the ones that we showed on that screen by Wired. They all, there's major authors that are suing major platforms. This is just one that's an example that I think is good to focus on. Complaint was filed back in December of 2023. OpenAI and Microsoft moved to dismiss. I'm just focusing on OpenAI for right now. They moved to dismiss in February of 2024, so about a year ago. They did not move to dismiss the entirety of the complaint. And as we'll see, they did not move to dismiss on fair use grounds. They did move to dismiss the direct copyright infringement claims to the extent that those claims are time barred. They are moving to dismiss the contributory claim based on the end user infringement on the ground that it is only alleging a generalized knowledge that end users may infringe, and there was no specific knowledge of any particular infringement, which OpenAI is arguing is necessary to claim contributory liability for copyright infringement. They're claiming that the DMCA claim fails as a matter of law. And we've, like I said, there's been a split of authority on that, even in the Southern District. Judges feel differently about whether those claims should survive or not survive, and that the misappropriation claim is preempted by the Copyright Act. We're not going to really get into copyright preemption today, though I would love to. It's one of my favorite topics to talk about. If BHPA wants to have me back, we can do a whole thing on copyright preemption, which I'm mentioning here, not just because it came up in that case, but because copyright preemption becomes a very important issue in these AI copyright cases. Why? Because of the nature of the various claims that are being alleged, including with respect to the web scraping claims based on things like breach of contract or trespass to chattels, when ultimately there may be an argument that all of those are ultimately in the nature of you copied my stuff claims. And there is an argument that the Copyright Act is supposed to cover all of the you copied my stuff claims, regardless of the style, how the cause of action is styled. So they're making an argument like that with respect to the misappropriation claim. After the motion to dismiss the original complaint, the New York Times filed a first amended complaint, really just to add some additional articles and copyright protected materials. I believe, I did not deep dive into this. What I do know is that there was no sort of second motion to dismiss. I think that the parties are all sort of like resting on the original motion, saying that nothing really changed with the amended complaint. The other big beat that's important to know is sort of in the fall of this past fall, the court consolidated the case by the New York Times by cases that were filed by other journalists, including the Daily News, not including, specifically the Daily News and the Center for Investigative Reporting. They combined those cases with the New York Times case, and so now OpenAI and Microsoft are facing multiple plaintiffs in those cases. And there was a motion to dismiss hearing in January, and now I think folks are waiting for the court's ruling. I wasn't able to attend that hearing. Maybe some folks on this webinar were able to attend that hearing. What I do understand from the reporting on that hearing is that there were substantive discussions getting into fair use and that big question. What's interesting though is that this case is going to be going on for a long time, and just to cue up what the fair use question is in that case, and I see this case again as like maybe the big kahuna or one of the big kahunas in terms of the fair use question. OpenAI is arguing that the use of the material to train these LLMs is fair use because it serves a new or transformative purpose. The New York Times, tries to preempt that argument right away in its complaint. They're saying there is nothing transformative about using the Times' content without payment to create products that substitute for the Times and steal audiences away from it. They also claim that because the outputs of the models compete with and closely mimic the inputs to train them, copying those works for that purpose is not fair use. And as I mentioned, OpenAI did not move to dismiss based on fair use. They're likely saving that for summary judgment after there's more facts that have been developed. And they are deep into discovery and all of the battles that come with a massive high stakes litigation right now. Okay, so I have 25 minutes left to talk about fair use precedent and do a little bit of a primer on fair use, and then we'll jump into the recent decision from last month. Like I said, this is not a 101 course. If people wanted to do Copyright 101, we would cover these in detail. For most folks here that are coming to this kind of course are probably going to be familiar with the 4 fair use factors that are set forth in Section 107 of the Copyright Act. These are non-exclusive factors, but every court goes through them, and they at least purport to drive decisions in these cases. Typically, the first and the fourth factors get the most weight, and with the second factor really sort of where on the spectrum is the copyrighted work in terms of like a really fictional creative work versus a non-fictional work, which gets less, and something that's more functional and reflecting ideas gets less protection. The third one, the amount and substantiality of the work, those two tend to get less weight. And so it is with the cases that we're going to talk about. No one needs me to cover these any longer, right? Okay, let's move on. Much more fun. This is Jeremy's grab bag of fair use decisions that I believe are going to play an important role as courts start deciding the big questions around fair use. And so I thought it was worth pausing and sort of reviewing fair use jurisprudence from the position of the most influential courts that have weighed in on this. So starting with the most landmark case on fair use jurisprudence, which is Campbell versus Acuff Rose. This was a case where the hip hop group 2 Live Crew did a song that was used guitar licks and used some of the lyrics from Roy Orbison's Pretty Woman, and the Supreme Court in that case held that this was a parody, which was in itself was a finding. They said that this was a parody, and that in order to do a parody, you needed to use the original. And they said that the parody was transformative, and it was a transformative use because it created a new work that shed new light and had new commentary on the original. And in order to do that, you need to conjure up the original and use it. So you had a need to use the original in order for it to be fair use. And the court really liked that they made something new. They made a new creative work in the process. And the term transformative use, that was a term that the Supreme Court of the United States borrowed from Judge Pierre Laval, who is on the Second Circuit and had written a fair use article, I think for the Harvard Law Review a few years earlier. And that became and has been ever since the prevailing terminology that courts use, which is whether the use is transformative. That is, some folks on this call may say, well, that transformative use test has swallowed the entirety of fair use, although courts tend to discuss it only in relation to the first factor, the purpose of the use. But we'll get into that in a little more detail. So parodies are fair use and they're transformative, Supreme Court says. Second case I want to cover is Sony versus Connectics. There's another case involving Sega. These are cases involving reverse engineering. And the Sony case, you had Sony, which had its PlayStation video game console. They made the PlayStation console, and Connectics made a emulator. They made for the Macintosh, I think for Windows also, they made a piece of software that allowed a Windows machine or a Mac machine to be able to play PlayStation games on your computer. Not something that Sony did, not something that anyone did. And in order to create that emulator, Connectics had to take the Sony PlayStation and reverse engineer it. And with it, the BIOS, the underlying sort of operating system of the console, which was copyright protected. And they had to copy it and study it in order to create this emulator. The emulator itself didn't use any code, didn't use the BIOS, didn't use any Sony materials. And the Ninth Circuit in that case said this was fair use. They said that this is transformative when you when you do reverse engineering to get to the functional elements and understand it, but they really liked that what you were doing was creating a non-infringing product, which was the emulator, and that it expanded the market and allowed consumers to sort of have new ways to play these games. And so in that case, the court held that was transformative. And even though it was undisputed that Connectix had made these intermediate copies of the BIOS, the court was willing to overlook it under the banner, under the flag of fair use. Next up, Authors Guild versus Google, and there's a corollary case, Authors Guild versus HathiTrust. Disclaimer, I represented the Authors Guild in those cases, but again, I'm not here in capacity as advocate, I'm here hopefully as educator. The Authors Guild sued Google after Google, in partnership with dozens of massive research university libraries around the country, Michigan, Wisconsin, in California, and they digitized, using scanning beds, they scanned and then used optical character recognition and digitized millions and millions of copyright protected books. They did that in order to make them searchable on Google Books, which is books.google.com, which is part of their search engine, and is, according to Google, this is further to their core mission, which was to make the entire world searchable. And they said it's not enough to make the web searchable. We want to make all books searchable as well. So Google had the Google Books application, and the university libraries had a consortium called HathiTrust, where they used the same sort of search index that was created in order to make those books searchable. So you can go onto a prompt, put in some keywords, and find where those keywords hit inside of books and on what pages. And Google, in the Google Books program, they would display a snippet, just a few words before, a few words after, and the text that you were looking for in the book. And the idea was so that you can then go and get the book and get the original source. Authors around the country, authors around the world came together and alleged that this, copying and scanning and digitizing of millions of books by a commercial juggernaut like Google in order to help them advertise was copyright infringement. The court, and here it's the Second Circuit on appeal, held that both in the Google case and in the HathiTrust case, held that this use, even though you had digitized and scanned millions upon millions of copyright protected books, when you did that for the purpose of making them searchable, that is a different use than the original. The court ticked through the factors, and I'm not going to get into super detail. But it was also interesting to me here that one of the reasons the Second Circuit found the use transformative and ultimately found it a compelling defense for fair use was because it augments public knowledge. There were also very other important factors. The court found that there was lack of a sort of a fledgling or existing licensing market for books for the purpose of making them searchable. Of course, lots of books get scanned and OCR'd for to be distributed as ebooks, but the court said that there wasn't enough evidence of a market for books for this specific purpose, and the court held that it was fair use. I mean, for folks that are sort of following this, to me, that case shares some hallmarks of the cases involving the generative AI, where you're scanning and ingesting millions of books. And you can imagine that OpenAI and the other platforms will be looking to cases like this to hold that they are on all fours. Although, as we'll talk about, there are arguments on the other side and reasons for distinguishing those cases. Next up is Google versus Oracle. And this one involved APIs, which are little pieces of software that allow computers to talk to each other. And in that case, it was the holding was that the API code, first there was a challenge around the copyrightability of the API code. Court said, let's assume it's copyrightable. The court found that Google's use of this API code that belonged to Oracle was transformative. And why? The reason they found it was transformative was because this code was necessary for other developers to be able to create new computer programs. And there's a theme here. It's like the courts and fair use and copyright in general really like when, if you're going to use something and it's going to cause other people to be able to create new stuff, they really like that. And by the way, you might have noticed I said when they use it so that people can create other new stuff, query how that might change when it's a machine that might create new stuff versus a person. I don't know. Interesting. Finally, let's just look at Warhol versus Goldsmith. Just came out a couple of years ago. I'm sure that case was covered ad nauseum at the Beverly Hills bar, as it was across all sort of bar groups that touch on copyright and entertainment. That was a case where one of Warhol sued, Goldsmith sued a photographer, sued the Warhol estate for licensing a Warhol work for the cover of a magazine. Goldsmith, the photographer of a picture of Prince, said, I licensed this for a commercial purpose to get a license fee so it could be covered on be the cover of a magazine. Warhol took that photograph and he did his Warhol thing to it of Prince, and he put his his sort of Warhol touch on it, and then the Warhol estate licensed it to be the cover of a magazine. And the Supreme Court in that case said, just doing the Warhol thing to the photograph is not enough when the original use and purpose is really the same as the final use and purpose. So looking at the original license for a magazine and then the secondary license for a magazine, and the court said just making these aesthetic changes, even though it's really cool, not enough. What I also want to draw from that case was the Supreme Court really focused on justification. What is the need for using that work? And in that case, the court said you didn't have enough justification for using that work. You could have gotten a license to use it. We'll pause for the CLE code, which I think I have to do. I'm assuming yes. Let's do neural, Neural. Now getting into the main event, Thomson Reuters versus Ross Intelligence. So the facts of this case, the beginning of the story, I would assume that 99 or 100% of you already know, which is that Thomson Reuters owns a little platform called Westlaw, which is used for legal research. And on Westlaw has headnotes and a key number system that they build around the public domain judicial opinions. The allegation is that Ross really in conjunction with a third party, doesn't really matter, that they used these headnotes and Westlaw's key number system to train its AI-based legal research tool. Now, importantly, and distinguishing this from the generative AI cases, this is not a generative AI case. This is not a case where folks put in, prompts and out pops, generative AI. Rather, the allegation in this case and the nature of the training, and actually to go to one of the questions that came in, was that this wasn't a case where where Ross Intelligence was creating an LLM from scratch. Rather, this was a case where Ross Intelligence was using some version, it was alleged, of Westlaw's headnotes in order to understand, as the way that I interpret this, is how actual people actually speak and ask questions versus how lawyers and judges talk in their opinions, right? So if you're trying to find a ruling and you want to get to the decision and not just get like some treatise's interpretation of it, the idea was that you wanted to be able to put in a prompt, a legal question, and then the AI tool would be able to search the judicial opinions and then come back and show you where in the opinion that to be able to match the plain language human being that puts in the question versus the opinion. Well, in order to do that, the allegation is that Ross Intelligence used the Westlaw headnotes to teach the AI to be able to understand how people ask questions and how people talk. So, on February 11th, so I say on February 11th because that's what happened last month, but what I'm also focusing on here is after previously indicating that Ross might qualify for fair use. I did a whole blog post on this. Several months ago, this court weighed in on summary judgment and held that fair use was a question for the jury and sort of looked at it and said, well, really what we should look at is whether the Westlaw headnotes were being used for their expressive purpose or were they being used for some other purpose in order to train it and just to be able to understand how language works. And so that was going to go to the jury. everyone in the case, the parties were getting ready for trial after the court had denied summary judgment, and were getting ready for trial. And then the court pumped the brakes and said, wait a minute, I'm not sure that I feel really comfortable with what I did on summary judgment. Kind of had everyone go back and do some weird briefing. I didn't exactly follow all of the beats of it, but out comes this opinion on February 11th after the court looked at it again. And, the judge begins the opinion by saying, I didn't put this in my slides, but judge says, oh, by the way, Circuit Judge Bibas, sitting by designation from the Third Circuit, sitting in the District of Delaware, says, a smart man knows when he is right. A wise man knows when he is wrong. Wisdom does not always find me, so I try to embrace it when it does, even if it comes late, as it did here. Great humility by this judge to reverse himself on the fair use ruling, and going from saying this is that we're going to let Ross Intelligence present fair use to the jury, comes back and says these materials are not fair use as a matter of law. Now this constitutes really the first major fair use ruling applying the fair use doctrine to AI training, and it could, of course, influence the other AI copyright cases, including the ones we talked about, though the court was very careful to say, I'm limiting my case to its facts, and saying that, this is not a generative AI case. He said that specifically. How did the court go through the fair use analysis in this case? Well, first starting with factor one, the purpose and character of the use. This factor looks at whether the use is commercial or non-commercial, first finding that it was definitely commercial. Indeed, the court really focused on the fact that Ross Intelligence's product is directly competitive with Westlaw. And then it got into the transformative test and looked at the cases like Sony and Sega, where intermediate copying had been held to be transformative. Indeed, in the case, in the last ruling by this judge, the court did a deep dive into those intermediate copying cases to rule that it was a fair question whether this was fair use. This time around, the judge had a much more skeptical view of those cases and ultimately held that those cases were inapt. The court distinguished those cases. I don't think I got into that exactly why. Yes. The court distinguished those cases and said, one, those were about computer code. And code is by nature functional and operates. Language in books and in literary works is not the same as computer code by nature. And so that's number one. And then relatedly, whereas in those reverse engineering cases, it was necessary to copy the API code, to copy the BIOS in order to understand it, and in order to create a new and interoperable product, court said here, there's no need in the same way to copy those elements in order to achieve your purpose of creating this legal research tool. The court also relied heavily and very interestingly on the Warhol versus Goldsmith case in looking at the ultimate use here and comparing, headnotes are used. I mean, I'm summarizing here, but headnotes are used. These headnotes are being used to create a competing product. The original use of the headnotes is to create a legal research tool that is used by lawyers primarily. And the ultimate use is a legal research tool that is being used by lawyers, and you're going to cut into market share, which of course flows into the last factor of market effect. The second one, the nature of the work, the court said, Westlaw headnotes are barely creative. Indeed, the court really had to struggle a little bit with even determining that the Westlaw headnotes were copyrightable in the first instance, given that they derived from opinions. And I think the court recognized that some of them are copyrightable, some of them maybe not so much, and that they're mostly factual. So the court did hold that second factor favors Ross, and the third factor as well, also holding that factor favored Ross. Interestingly, the court said, the fact that you copied thousands of them in training, yes, that's true, but the court also focused on the fact that the Westlaw headnotes were not output to the users. So what's interesting about that is that the court's focus on the output, to me, what's interesting, the court's saying that the output of the Westlaw head notes never being shown to the user, by focusing on that primarily with respect to factor 3, the court, in my opinion, might have de-emphasized that factor a little bit. As I mentioned before, factors 2 and 3 tend to get a little bit of short shrift from the court in terms of the weighting of the 4 fair use factors, and Ross Intelligence was relying heavily on the fact that the output wasn't shown, much like in the Google Books case of saying we're only showing a tiny snippet out of the entirety. The court didn't buy it, and the court said, "Here, fine, it favors you, but it's only in the 3rd factor." Finally, like I mentioned, market effect. The court held, 1, you're competing with them and potentially taking market share away from Westlaw, and also the court noted that materials are being licensed, that there's an existing and fledgling and growing market for AI, for copyright protected materials to be licensed to AI companies for training purposes, and you undermine a potential licensing opportunity. And the fact that Thomson Reuters wasn't doing it yet was of no sort of moment to the court. They said, well, they could, and they chose not to. And indeed, Thomson Reuters has its own AI legal research tool that I started using recently. It's pretty good. So just sort of key takeaways from this case. One, and things I mentioned, one is, the court really emphasized that this is not a generative AI case, and it addressed, a competing legal research tool. I think that is really important to focus on. This was one of these vertical AI applications. It is not a general purpose AI tool. It's also not a foundational LLM or a general purpose, tool. This was specifically for legal research, and the training materials were from a particular vertical. So you have vertical of vertical. I think maybe that's important. Also was interesting, I noted before, significant reliance on Warhol. When that Warhol decision came out, there were many fair use advocates that were concerned that that case would be interpreted to limit fair use. And I think this might be construed as an example of that, where the court was looking really at the ultimate uses and what the need was for the original, and finding that where the secondary use competes with or shares a similar purpose with the original, not transformative. I think from an industry perspective, at least right now with this one decision, it really you could start seeing a separation of or a signal to certain AI models and technology that are being trained on specific materials that compete, and thinking, oh, you know what, this may not ultimately be held to be fair use, and that it may be better to go and get a license, at least for those types of applications and sort of models that are leveraging generative AI models. And then finally, this is very early. It's still very early days in the jurisprudence. This is really the first ruling from the District of Delaware, district court ruling. We don't have any word from sort of the courts that, tend to form the big cases here, the Second Circuit, the Ninth Circuit, the Second Circuit. Look, the Third Circuit could be the one to do it. I'm just saying that none of those circuit courts have weighed in. They could reverse this. Courts in the other jurisdictions could adopt different views of fair use. And so it is by far not the final word. To me, these cases are, ripe, the big question, ripe for Supreme Court review, although I would argue that maybe some of the circuit courts are just as well positioned as the Supreme Court to weigh in on this stuff. Who knows? So with that, I'm going to stop there and not talk about the other things because we only have 1 minute left. I think there's a fair number of questions to address. All right, so, a question I've been asked about whether it's possible to constrain AI learning to specific sets of data. Well, I don't know. I don't know the answer to that. I mean, I think the answer there is like a technical question about whether you can, only have certain amounts of data. I think the key thing to understand is that with respect to the large language models, from the perspective of OpenAI and its brethren that are creating the foundational models, key argument that they are making, one of the key arguments that they are making in favor of fair use is, we can't just go and license like Westlaw head notes or maybe even an entire library in order to train our AI. Rather, in order for us to make this technology work, in order for it to understand language, all languages, in order for it to understand all of human culture, we need everything. It's kind of like a little bit of an all or nothing kind of thing. And so I think one of the arguments, very interestingly, is, usually with fair use, it's like you're trying to limit the amount that you take. I think the argument here is we really needed it all in order for this to provide the functionality that we're providing. Question, is there a chance that fan-created work could be protected by case law or future statutes? I think I think that it's the same as all. I think it's very hard to argue that it's different than any other sort of copyright protected work in terms of the protection. I think that people are going to do them pretty much with whole cloth, and in a fair use analysis, sort of the type of the work. Once you pass the copyright threshold, I think you end up in like that factor two. What's the nature of the work? And I don't know if you mean like fan fiction, which is a separate idea. And I don't think that they're gonna get separate treatment personally. Mark is just talking with Jay, who's of course very capable of answering all these questions. So, and Mark's just talking to Rosemary. Mark says, worth discussing the concept of torturing AI models to output any content you want, including illegal content. This is why Midjourney used to include its terms that they will go after any end user who knowingly does it. Yeah, I mean, it's true. I think this goes to this sort of one of the big sort of battles, I think, is just like who should be held liable to the extent that there's copyright infringing content that comes out of AI and either just like is shown to a user, which is to me like a little bit of like a tree in the forest. I think the bigger deal is like when these AI tools generate content that is infringing, and then they use that for a commercial purpose, or somebody takes it and publishes a book, or puts it on a movie, and then somebody says, no, my material is used to ingest that. Who's liable for that? Is it the user? Does it matter kind of what kind of prompts they put into the machine in order to generate that? Or does the AI model have potential secondary liability there? I think those are some of the really big questions that are being asked. Did Ross have no legal advice, bad legal advice? I can't answer that question for sure. Jay, I mean, so why couldn't Ross just use the public domain to judicial decisions? Why did it need to use the headnotes with their albeit minimum copyright protection? Well, great question. I mean, the point there is, I'll say what the judge really picked up on that, and I think he agreed with your very leading question, which is, authors get paid to create stuff, and Westlaw, Thomson Reuters paid legal writers and the like to create Westlaw headnotes, and they got paid for that, and that was expensive for Thomson Reuters to do. And if Ross wanted to, could have created its own, or it could have used public domain. Well, let me just take a pause. Jay, I think the key distinction is that the judicial opinions themselves weren't necessarily enough to train the AI, because what they were trying to do to train the AI was create sort of bite-sized questions, or the equivalent of bite-sized questions, which essentially are like headnotes, right? You're taking, these long judicial opinions and you're breaking it down into its constituent sort of issues and parts. And so really, it's not like, could they use the judicial opinions? There, the answer is yes. But in order for them to train the AI to achieve what it wanted to achieve, there really needed to be some distillation of that, and maybe some human authorship there. And the court said you could have created your own. You didn't need to use Westlaw's. You could have created your own and paid your own authors to do that job. Well, I like this question, which is, could I provide a link to my blog? Sure. I will do that. I can stop sharing. And yeah, I'm going to do that because here's my blog. I mean, this is my own, that's my own personal blog that I just typed in. I don't know if that worked. And what else? Are we good? We're at 11:05. I see. Oh, Jay is hitting back. Surely AI can summarize long judicial opinions. I agree with the court. Maybe. It's interesting, Jay. It's a good question. Like in 2020, I don't know that that's the case. I think when they started doing what they were doing, there wasn't sort of off the market ChatGPT available to do that, and I don't know how good ChatGPT would do. I don't know how well ChatGPT would be able to create head notes. And I think Thomson Reuters would argue that they do a much better job of it through their human authorship and lawyering. And I hope maybe that's true. I don't know. All right. Well, thanks everyone. Hope you enjoyed it, and feel free to reach out if you have questions or anything.
All right. Well, I'd like to thank you, Jeremy, on behalf of the Entertainment Law Section of the Beverly Hills Bar Association, for your insightful and timely program today about AI and fair use. Thank everyone for joining us in Jeremy's presentation. And also, Jeremy, I'd like to accept, definitely on behalf of the Beverly Hills Bar Association, your offer to come back to continue with additional CLE programming. I know we would all appreciate that, and we appreciate your time. So thank you.
You're welcome. A lot of folks are asking for slides. Should I will send them. Are you able to distribute those out to folks that attended? Is that a thing?
Yes, why don't you send us the materials and we will send to the attendees.
All
Thank you
right.
very much for that.
Thanks, everyone.
Thank you.
Bye.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.